Okay, well, we can do this a lot more informally than we usually do, but what I'm going to be talking about today are goals. And of course, you guys, I think, were both in the other presentation. And so we did talk about kind of due process hearing stuff. And I'll talk about some of that too. But primarily what I want to talk about is the substantive side of what we're talking about. And we went over that a little bit, but I'm going to spend some more time on that. And I do have to say, too, it's another great conference. Jolly and Matt and the gang put on some really good conferences. And if you haven't gone, I would encourage you to go to the law conference in the summer. It's really good, and a lot of good folks here. But at any rate, so we're going to talk about goals and progress monitoring. First off, I have this little QR code. That QR code, of course, is for the IEP. The State Department wants you to fill that out. So I'll have that later, too, that you can look at. But what we're going to do today is I was going to start out talking about the substantive requirements of IDEA and then Article 7. And then talk about the two most important, well, there's probably three most important parts of the substantive, and that's, of course, the assessment. But what I really wanted to talk about was the measurable annual goals, and a three-step system that was developed in the 50s for writing measurable annual goals that I think is absolutely the best way to ensure that goals are actually measurable. And one thing I should say, and Matt could probably back this up too, is that of the probably close to 1,000 IEPs I've looked at grants and things over the past number of years, goals tend to be not measurable, and that's a problem now that the idea really requires, or the Supreme Court is required, is to write measurable goals, or actually to write IEPs that are likely to or reasonably likely to confer progress. And if we don't have a way to measure, how can we say a child is making progress? So that's. And talk about this three-step method, and the last thing I'm going to do is talk about monitoring student progress and how that also is a very important part of the requirements of the Ender decision. And before I start, I just wanted to say, and we talked about this yesterday too, is the primary requirement really of the IDEA and Article 7 is that, and it's really our crucial obligation, is that we write IEPs that confer a free, appropriate public education on youngsters. So, the question is then, what is a free, appropriate public education? And back when I was teaching, I was a teacher in Minnesota for 14 years, primarily in upper elementary and middle school for youngsters with emotional and behavioral disorders. Actually, in Minnesota, at the time, they combined the two categories and called them special learning and behavior problems, or SLBP. And I taught in that area for 14 years. And I started teaching just a few years after the regulations were written for what was then called the Education for All Handicapped Children Act, which is now we call it, of course, the Individuals with Disabilities Education Act, or the IDEA. And back then, if I had said the name of it, the Education for All Handicapped Children Act, people probably wouldn't have known what I was talking about, because almost everybody referred to the law as PL 94-142, because that meant the 142nd public law passed in the 94th Congress, PL 94-142. And it was easier to say than the Education for All Handicapped Children Act. So, but the idea isn't easy to say. But the important thing we understand here is that definition of FAPE has not changed since 1975. That has been with us ever since the law was PL 94-142. And we'll go through the components of that real quickly. Sorry, I know I did this yesterday, but it's very important you understand that everything we put in the IEP has to be provided at public expense. That's the first part. of the idea. The second part is it has to meet the standards of the state educational agency. And since we are in Indiana, we have to follow Article 7. If it exceeds or grants more rights to youngsters with disabilities than the IDEA does. Well, the Indiana does this in very few areas. There's only one real meaningful difference in IDEA and Article 7, and that's in the transition programming, where of course the IDEA says we have to have transition programming provided at age 16 in Indiana. Article 7 says, 14 years of age. So that means you have, this state actually gives more rights to youngsters with disabilities than the IDEA does in this one small little area. So that means you have to meet the standards of the SEA, or the state educational agency. So that's required. Now, some states like New York and California have a number of differences, and as long as those differences exceed the rights given to children under the IDEA, that's fine. But if they're less than the rights, states can't do that. Yes?
Did you say for the IDEA, the transition age was 16?
16 years of age, yep, under the IDEA. It'll probably, if the law is reauthorized, it'll probably go back, because pretty much every state has moved theirs to age 14 now. South Carolina has actually gone to 13. It'll probably be changed next time the law is reauthorized. And the reason that is done is kind of interesting, because under the Constitution, the federal government has no right to legislate on education. That's the right of the states, because the federal government can only legislate in areas in which the Constitution says they can legislate. And the Constitution doesn't mention education, so education becomes the right of the state. So the way the smart folks of the federal government get around that is they write what is called a program law. And essentially in IDEA, the way the program law worked is they said, if you states write state plans that meet our requirements under the IDEA, we will give you a lot of money. In fact, they said originally, we'll give you 40% of all your state's excess costs in educating students with disabilities, which, of course, is probably at least double the cost of educating a youngster without disabilities. And so that was pretty attractive. All states but one bought into that and said, fine, and passed wrote state plans, and in all cases actually have eventually developed their own laws that mirror the IDEA, like Article 7. If you read that, that's just the same. That's the same thing as the IDEA. There's very little differences, some language differences, and then the transition's a little bit different. So that's why Congress put that second part in, just to ensure that we live in a cooperative federalism system, and therefore states are really important. So yeah, you have to follow our law, but you also have to remember, follow the states. But states can't offer less, because you're accepting the coins of the king, and the king says you abide by these terms, you have to abide by them. So that's essentially why. But it's kind of interesting that where Congress originally said 40% of excess costs, they never provided states more than 14, 15%. So that's a lot of money still, but not as much as Congress originally promised. Includes preschool, elementary, or secondary education, and then very importantly, a FAPE is provided in conformity with the IEP. The IEP, of course, the Individualized Education Program, primary document of special education. And as David and I were talking about yesterday in our presentation, from a due process hearing officer standpoint, probably about 95% of the cases we hear are FAPE cases. They're about what exactly is a free, appropriate public education. And you know what that always comes down to? The IEP. What was written in that IEP? How did the team collaborate with the parents in developing the IEP? And even though this definition has been with us since 1975, it's not a really clear definition. In fact, and again, I think I mentioned this yesterday, the Supreme Court even said that in a decision in a case called Board of Education v. Rowley. They said, boy, we would have wished for a better definition, a more clear definition, but we're the Supreme Court and we have to figure out what Congress meant when they required that all our programs confer FAPE. Well, in fact, this wasn't an accident, that this is not a real clear definition. Because, and let me go back here for a second. I'm going to go up for a bit. Okay, Robert Stafford, who was a senator from Vermont, who was a co-author of the original Education for All Handicapped Children, wrote in the Vermont Law Review in 1978 that it was deliberate. They deliberately did not define what FAPE was for the courts. They left it up to us, we folk, as special educators, by requiring this baseline mechanism called the Individualized Education Program, or IEP. And like I said, the Supreme Court wasn't really crazy about this, but they had to figure out what Congress meant. Because what the courts have to do, of course, is interpret law. And they interpret the laws as written by Congress, signed by the President. And in 1982, there was a case called Board of Education v. Rowley that the Supreme Court heard. It's the first special ed case ever heard by the Supreme Court. There had been many lower court cases at that time. And it was the very first case on a FAPE. And the reason is that is the big issue in special education. That's where most controversy occurs, is a school district providing a free, appropriate public education to youngsters with disabilities. In 1982, the Supreme Court decided to hear Board of Education v. Rowley. That was pretty interesting. I was a master's student in special ed at the time, and I remember people were really worried that might be the end of IDEA, that the Supreme Court, which was relatively conservative at the time, would say the idea was unconstitutional and would do away with it. And IDEA or special ed would go back to the states. And as we know, up in 75 or even in 82, states were very uneven in terms of what they offered to youngsters with disabilities. That's not what happened. In the Rowley case, the Supreme Court decided in favor of the school district, who was offering Amy Rowley an education. Amy was a very bright child. She had about 125 IQ, so really not kind of the typical child we see in special education. But she won in her lawsuit against the school district because the parents wanted, because she was profoundly deaf, they wanted a sign language interpreter in her class. And after a week of trying one out, the school decided, no, we won't provide a sign language interpreter. And so the parents said, well, this new law says you have to provide a FAPE. And here's what we think a FAPE is. We think it's equal educational opportunity provided to youngsters with disabilities that allow them essentially to make gains to fulfill their maximum potential. And that view held up in the district court because Rowley's actually lost at the due process hearing. It went to a district court, but they won because the district court really had nothing to go on. I mean, at the time they had that very bare bones definition and they had to figure out what it meant. And so they thought, well, yeah, that sounds like a good idea. It means that an education should provide equal opportunity and children should benefit to their maximum extent appropriate. And that was the position of the district court. Then that case was appealed to the next higher level of federal court, the U.S. Circuit Court of Appeals for the Second Circuit, and they agreed. They said, yes, it means maximum potential, that our programs have to allow children to achieve to their maximum potential. Went all the way to the Supreme Court, and they said, that's not what FAPE means. That's not what we believe FAPE means. FAPE means that kids should be accessing education, But it doesn't, the idea doesn't really talk about any substantive, what they call substantive elements of FAPE. I mean, it doesn't say how they should benefit. And so the Supreme Court developed a test, because the Supreme Courts of appeals like to develop tests because that gives a lower court a way to assess. So under this test they developed, if a lower court in Indiana gets a special ed case about FAPE, they have to follow what the Supreme Court said. They have to apply the same test. If I'm in South Carolina as a hearing officer and I get a FAPE case after the Rowley case, I have to apply the Rowley test. And this is what it said, what the Supreme Court said is, to determine if we provide a FAPE to our youngsters with whom we work, schools have to meet two parts of a test. And the courts are going to determine this. The courts have to ask these questions and answer them. And the first question is, has the state complied with the procedures of the law? Well, the procedures set forth in the law are things like, do you have the right people on the IEP team? Are you including the parents in a collaborative effort to write the IEP? Are you meeting all your timelines? Are you giving procedural safeguards, sending out prior written notice? All those things are procedures, and that's the first thing a court will do, or a hearing officer will do. If there's a FAPE case, they will ask, did the school follow the procedures of the law? That's why procedures are really important. And as you all know, well, I was a teacher in Minnesota for 14 years, so I remember every one of those 14 years, the second day in our new school year, we had a meeting of all the special ed teachers and the special ed director, and she went over our procedural handbook and went all through these procedures again. So that's important. That's the first part of the test. But the second part of the test was even more important, and that is the IEP or the resulting IEP reasonably calculated to provide educational benefit? The court said, well, clearly Congress would not have put all this money into the states to provide an education that just merely said that you have access, that you have to provide benefit. So the benefit part became really difficult, because I remember hearing a case as a hearing officer in 2015, 2 years before the Andrew case, and it was a FAPE case. And what every FAPE case boils down to is what is in that IEP. And so I had to look at it and I had to ask these two questions. Did the school district follow the procedures? And then, did the IEP confer meaningful educational benefit? So this is a very important thing, this test developed by the Supreme Court. But other courts had a really difficult time, not with the first part. The first part was the easy one. What are the procedures? Well, the law is really clear about the procedures that have to be followed. So the procedural part was not difficult. Courts just looked at what the school did, matched it to the law, and said, did they follow these procedures, yes or no? But the second part proved very difficult, and that is, what is educational benefit for any given child? Well, for Amy, in the Rowley case, Amy, remember, had 125 IQ. She's a very bright little girl, one of the top achieving kids in her class. So the Supreme Court kind of didn't really have to answer, was the IEP, did it provide educational benefit for Amy, because she was so bright and doing so well anyway. They just said, well, you know, she's passing from grade to grade. She's one of the top students in her class. Clearly, she received educational benefit. And and they also, however, in a footnote in the decision said, educational benefit is passing from grade to grade for Amy. That's not what it is for other kids. What it is for other kids must be determined individually. But some courts kept using this. Are kids passing from grade to grade? And virtually all the time now, that is not really a legitimate sort of defense when schools say, we provided a FAPE because little Johnny passed from grade to grade. But at any rate, because courts had such a hard time with that, we had courts, all the United States district courts in 6 different circuits, we have 12 of them that deal with special ed, said, well, that's a real low standard. That just means if school provide benefit, no matter how small, that's okay, because that is benefit. That's what the Supreme Court said. So in 6 circuits, if a child just got some degree of benefit, that would be enough to declare that they had gotten a FAPE. But other circuits were saying, no, it has to be meaningful benefit. Children have to benefit meaningfully from it. And so we had a split. We had some circuits saying low benefit, some saying high benefit. And whenever you have a split in circuits, they're saying different things, the Supreme Court is eventually going to step in to try and solve the problem. And that's what they did in 2017 in a case called Andrew F. v. Douglas County School District. They stepped in to solve this problem. And the problem was this: only one issue the Supreme Court examined, and that was the educational benefit provided in an IEP for Andrew F., who was a young boy with autism, was it sufficient to confer educational benefit? And they said that educational benefit is not clear enough. Clearly the courts are all over the map in terms of what that means. So we're going to provide a new test. And the test involved the FAPE, or the IEPs, of a young boy named Drew. And Drew was a youngster with autism, very serious problem behaviors, academically not doing well at all. And so when the Supreme Court looked at educational benefit, they said that term's not good enough. We have to come up with some new words, and if anything, it means more than insignificant benefit. It's got to be good benefit. So here's what the Supreme Court came up with in what we could now call the Rowley-Andrew test, because the first part is still there. The procedural requirements is still there. But they changed the substantive requirements as follows. They said, is the substantive requirements are this: is the resulting IEP reasonably calculated to enable a child to make progress appropriate in light of his or her circumstances? So they threw out educational benefit and put in progress, which means forward movement. It means they are making progress. And actually, when applied to Andrew, the school had done a good job of meeting the procedures, but when it came to the progress part, the Supreme Court said, lower courts, you figured this out. Did Andrew's IEP confer progress appropriate in light of his or her circumstances? And they did something called remanding, which is they threw it back to the lower courts to make a decision. And finally, in the district court, the district court made a decision, but because the Supreme Court was basically saying, your old decision's no good, now make a new one based on this new standard, the writing was sort of on the wall. And what the district court said is, no, the IEP was not appropriate. It did not provide FAPE because it didn't allow Andrew to make progress appropriate in light of his circumstances. So what we have there is the Supreme Court kind of out of whole cloth saying the idea has procedural and substantive requirements. The law is chock full of procedures. If you ever read the idea or you read Article 7, you'll read so many procedures. And you'll read very little on substance. Neither Article 7 nor IDEA really contain a lot of information regarding what does appropriate education mean, or progress appropriate in light of a student's circumstances. But nonetheless, we have these two areas that as school district personnel, as administrators, as IEP team members, our IEPs have to meet both categories. That is, we have these two dimensions of FAPE. And we actually even have a third dimension, and I'm not going to really talk about it. I'll go into it a little bit. But let's just go through these three dimensions. The first dimension is procedural, that as IEP team members, as administrators, we have to ensure that our IEP teams are meeting the procedures of the law. And what are the procedures? All the procedures in Article 7 and IDEA really revolve around one thing, and that is, are you involving the parents? You have to involve the parents, child's parents, in the special education process. That's what all those procedures are really about. And they are kind of, you could say, they involve kind of the how and the when we do things, and who we have to have on the team, and what we have to put in the IEP. All those things are the procedural requirements, and that was the Rowley part of the test. Now the second part of the test, which was actually changed in Andrew, are the substantive requirements that really mean our IEPs must be written to confer progress, or confer FAPE, which means educational progress that allows the student to move forward. That is really the what of IEP development. Julie Weatherly, who is an attorney out of Alabama, who has worked her entire career with school districts in special education, refers that to the content standards of the IEP. That is the content appropriate for a child's needs, and it will allow that child to make progress that's appropriate given that child's unique individual circumstances. That's the second part of the test, the Rowley part of the test, or excuse me, the Andrew part of the test. And that's the part that really focuses on what we do when we're writing or developing the IEP in terms of a number of things: assessment, the goals, the progress monitoring. So those are the two big dimensions that we have to be concerned with, procedural and substantive. But courts have also said there's a third dimension of FAPE that we have to be concerned with, and that is implementation. And there are a number of cases, going back to 2007, in which parents have asserted that school districts did not provide FAPE or denied their child FAPE because the school district either failed to partially or fully implement the IEP of the child. And one of the cases, MCV Antelope Union High School District, that addressed that specifically, has this point in their opinion, in the ruling, that the IEP is like a contract. It embodies a binding commitment and provides notice to both parties as to what services will be provided to a student. In other words, it's like a contract. We know that IDEA is unlike a contract in that the IEP does not guarantee success. Because remember, if you remember, Rowley said the FAPE is not about maximum potential. It's about, is it appropriate for a child? And so, but it is like a contract in the following way. If we write something in that IEP, it's incumbent that we implement the IEP as we wrote it. So for example, if there was a case a number of years ago out of West Virginia where an IEP was written in which a young child of high school age had an IEP that said, well, let me go back. He had an IEP meeting. During the IEP meeting, there was a health teacher, a social studies teacher there, and a math teacher, I think, and your usual LEA rep and special ed teacher, and of the three general ed teachers. And one of the general ed teachers said, if little Johnny, and that wasn't his name, little Johnny, he was called that by the court, he was called John Doe. If little John takes a test in my class, in my science class, He loves science and he knows it real well, but if I require him to take a test, he's going to fail it. Why? Because he can't read. And he would not know what the questions were. So what I do is I have a peer read the test to John. And the IEP team said, that sounds like a great idea. We will have a program modification in which we require all general ed teachers to read the test, their test to little John. And everybody was fine with it. They put it in the IEP. Parents were happy. Life goes on. They went home. At the end of the semester, little John comes back with his report card, showed his parents, and he had an A and a B and another A, and he had an F in social studies. And the parents said, Johnny, you love social studies. You always talk about what you're learning in class and things. Why did he get an F? And he said, well, Mr. Withers, my teacher, wouldn't read the test to me, and he wouldn't assign any other kids to read the test to me. And so the parents were pretty outraged. They called the principal of the school, and they said little Johnny failed because the general ed teacher did not honor the IEP. The IEP said you have to read tests to him. He said you don't. They called in, had a conference with everyone, and John Withers also said, well, the reason I chose not to read the test to the kid is because my class is a level playing field. I don't give favoritism to anyone. Of course, failing to understand that reading the test to Johnny puts him on the level playing field. It didn't do him any favors. It didn't give him a leg up on anyone. So the bottom line is, the parents didn't actually sue under the idea. They sued under another law, and John Withers wound up paying like a $25,000 fine for not following the IEP, because he, as we all are as teachers, is an actor of the state. We are working for the state, and we have to follow the laws. And in this case, they said John Withers was specifically not following the law. So that's just an example of how the IEP is like a contract. Now, maybe little John didn't meet his goals, but what is for sure is the contract wasn't honored, because John Withers, the social studies teachers, refused to read tests to him, where the IEP signed by parents and all the teachers said, you will read the test to him. So, you see, that's an implementation failure. Now, like I said, although this case was brought under a different law, if it had been brought under IDEA, it likely have been declared a material failure to implement. That's a denial of faith. And why that is important to remember is in elementary school, and especially in middle school and high school, where you have a number of teachers, if there is any program modifications in your IEP that teachers need to implement, they need to implement them. It's not the IEP does not provide teachers with a choice. It's saying this is what we will be doing with respect to a child's education. So in other words, we have to implement exactly as agreed upon. Now, courts will quibble about things like that. Was it a material failure or not? But for us, we should consider any failure a material failure. We want to make certain, and this is especially important for administrators, make certain that your IEPs are being honored, or that in itself could it be a denial of faith. So, here, the important thing is we understand that the IEP is the blueprint of a student's fate. Every IEP I get, as a due process hearing officer, I should say, that I look at, that is the child's fate. So if I'm making a decision regarding fate, that's what I look at. I look at a number of things, but the IEP most importantly, because I want to make certain it's procedurally correct, it's substantively correct, and it's implemented as written. It's very important. It's also, I think, I'm going to shift now. That's all I want to talk about, implementation. I'm going to go back a little bit and talk about substantive. But this is a quote from the Supreme Court in Andrew F. And you can see the importance that the Supreme Court put on progress. In fact, I was at the oral arguments, myself and David Bateman were at the oral arguments, and Justice Sotomayor at one point said, we believe, or I believe, the idea does require more than educational benefit. But our challenge is to find the right words that help courts to understand it is more than meaningless or insignificant educational benefit, that the educational benefit must be meaningful. And in the final opinion, written by Chief Justice Roberts for a unanimous Supreme Court, which very seldom happens, he wrote that the IEP must enable the child, or aim to enable the child to make progress. After all, he said, the essential function of an IEP is to set out a plan for pursuing academic and functional advancement. So, thus, if we look at how can we ensure that our IEPs do plan for pursuing academic and functional advancement, it's important that our IEPs positively or answer 4 questions. You know, IEPs are pretty complex things, but at the basis there are 4 issues that really go into making a substantively accurate IEP, or an IEP that meets, in our opinion, the Andrews Standard. And the 4 questions that your IEP must answer is, number 1, what are the student's unique academic and or functional needs that require specially designed instruction, and that has to be answered in the IEP. Number 2, what measurable goals will enable the student to make academic and or functional progress? 3, how will we monitor a student's progress toward these goals? And 4, what individually designed services will enable a student to achieve his or her goals? So in essence, we have these 4 steps. If we put them in terms of steps, it's step 1, make certain your present levels of academic achievement and functional performance address all of a child's given needs. Number 2, write goals that are measurable, that can actually be measured, and then you do actually measure them, because you have to write in your IEP a method to monitor student progress, or a method to measure a student's progress toward those goals. 3 or 4 is then you have to develop the special ed services that'll help a child to meet those goals, or which address all of a child's needs. So those are the 4 big steps, and we're going to talk about step 1, 2, and 3, and really concentrate on step 2, and also talk about 3. But it's important that we also look at step 1, and this is why it's important. If we look at, say this represents kind of the big picture of IEP development. What's the first thing that comes before the IEP is written? You conduct an assessment. And that assessment becomes the foundation of a child's IEP. Everything that comes after it is built on this assessment. Well, we know in the initial IEP is really about determining is the child eligible, but it also has to help us as IEP team members develop a child's program. And the educational programming then is built on this assessment. And the educational programming is those things we put in the IEP, and the substantive part is really the services and the goals that we put in the IEP. And the last thing, of course, is we have to have a way to report a child's progress toward their goals to the child's parents on a regular basis, using a system where we monitor progress during the course of instruction, which is called formative evaluation or formative assessment. So that's very important, you understand. Assessment has to be full and individualized and meet all a child's needs. Doesn't matter what you call them. I was at a conference last year in which I was told by a teacher that their LEA rep said, directed the assessment. And when they were determining the assessment, went to the school psychologist and said, well, this child is learning disabled, so we don't have to look at behavior. Well, the referral did say behavior was a problem. Does that mean because we call them EBD or emotionally disturbed, we don't have to look at behavior? Of course not. We have to look at all of a child's needs. And so that's why the assessment is so important that we get that right. A U.S. District Court actually in South Dakota talked about the IEP team or the IEP like a house. If the foundation is bad, the judge wrote, the rest of the house is going to fall. And a number of cases have said this. If the assessment isn't done correctly, probably everything in the IEP that follows it is going to be incorrect. Why? Because it's based on less than accurate summation of a child's needs. So that's a biggie. As a hearing officer, that's one of the things I look at in a FAPE case. What was assessed? What was included in the child's present levels of academic achievement and functional performance? Were all those needs there? If they are, that's a good solid foundation. If they're not, bad foundation, the house is not going to stand. So the IEP is likely going to be ineffective or not provide a FAPE. Now, a second thing we always look at, or I always look at when I have a FAPE case, is the internal consistency of the IEP. And that just basically means that everything is connected. That we have, from the current assessment, we've developed our present level statements and functional performance statements. And by the way, in 2004, remember what it used to be? Present levels of performance. People called them PLOPs or PLEPs. In 2004, they changed that to academic achievement and functional performance, really to stress that we're not just about academic achievement. We're about functional performance. And although IDEA doesn't define that, the regulations essentially say functional performance means those skills a child needs to succeed in life outside of academics, like socialization, communication, behavior, those sorts of, that's the functional part. Now, when we identify those needs, to have an internally consistent IEP, we have to make certain they're addressed at other points. One point is the annual measurable goals. They have to be ambitious, but just because there's a need doesn't mean there absolutely has to be a goal. So in Johnny's case, John Doe's case, if he had the need, if they decided he needs his books, his tests read to him, you don't need a goal on that, but you do need a service. Every need that's identified here has to have a service. Now, a lot of them are going to have, especially if they're academic or functional, going to have a goal. But they have to have a service. Now, one of the things I do as a hearing officer is when I sit down, first thing I do is I read the decision of the hearing officer. Then I look at the briefs. The attorneys have to give me briefs about their stance in terms of did they agree with the hearing officer's decision or not. Then I read the transcripts. Then I look at the exhibits. And then I make a decision. I decide, well, did the hearing officer get the facts right? And then did he apply the law correctly? Well, I had an IEP, a case in 2015, in which a young girl with moderate intellectual disabilities had an IEP. Parents disagreed that it provided a FAPE. They said this IEP does not provide a FAPE, and they couldn't get the issue addressed in the IEP team meeting, and so they asked for a due process hearing, filed a due process complaint, went through the resolution, wound up going to a hearing officer. And in our state, we have two-tier of hearing officer. The first hearing officer looked at the IEP and said, well, that provides benefit. And this was actually 2015, before the Andrew decision said you have to have progress. It just said benefit. And they said, well, the IEP did provide benefit because she did make some growth. And so he decided in favor of the school district. The parents appealed to the state. And the state attorney asked me if I would be the due process hearing officer on it, which just means I don't call a case, I don't listen to more witnesses unless it's absolutely necessary. I just look at those exhibits and read that transcript. And I went through the case and I found that little Amy had speech and language problem, she had a reading problem, she had a math problem, she had socialization behavioral issues. So I decided, well, let's look at the rest of the IEP. So I go through the IEP, wrote down the needs, looked at the goals. Well, there was two goals in speech and language, a couple goals in reading, a couple goals in socialization behavior, no goals in math. So I thought, well, let's see if they're in the services, because all needs, which they identified math as being a need, have to be reflected here. So I looked at them. Yep, there were speech and language services, there were reading services, there were behavioral services, but no math services. So what we had was an internally inconsistent IEP that said, here's Amy's needs, here are our goals, here are services, but one of those needs was not addressed in the rest of the IEP. So I overturned the hearing officer's decision. Why? Because the IEP was internally consistent. Not all the needs were addressed. So essentially that means everything has to be connected. If you have needs, they should lead to goals. Most of the time, all the time, lead to services. So one component leads directly to the next component and the next component after that. Now the last, yes?
So in the case of Johnny, where you said that he didn't necessarily need a goal, that the accommodation of having tests read aloud was sufficient.
Yes.
I have a two-part question. So then you guys wouldn't feel like in that case that the reading, actual base reading issue wasn't being addressed through a goal. And then if we have a situation like that, how does a school district show progress if there's not a goal attached to the service?
Well, and that's a very good point. How can you show progress if there's not a goal? Well, yeah, you can. If you don't have a goal, you can't show progress. But in John Doe's case, he had an accommodation, not a goal, for reading tests, and the teacher just didn't do it. They failed to implement.
Right.
So, but he did have reading goals.
Okay.
And they addressed reading issues, but that was not the problem the parents complained about. They complained about the implementation of the IEP.
Could you give us an example of a situation where a student would have a need that could be justified by a service but not meet a goal? Because I guess I'm just having a hard time understanding where that would come from.
Okay, yeah, the question is, could an example of where a child would need a service but not need a goal?
Yes.
Okay, well, let's say that you have a child with visual impairment and you decide you write a supplementary service or program modifications that the district will buy large print books. And all his mainstream classes, social studies, history, whatever, will have large print books.
Because you're not going to
You don't need it.
be able to improve the vision.
You won't be able to improve the vision. So you have a service you'll deliver, but you don't have a goal.
Okay,
so it's very rare, though, and that's a very good point. Usually, what a need will lead to a goal, but not always.
Okay.
Yes.
And just to piggyback off what Sarah was saying, so say, for instance, she does an evaluation and the student comes up with basic reading, a deficit in basic reading, reading fluency, and but there's in written expression. But there's really only a goal to address the reading. There is no goal to address written expression or oral fluency, but there is a service provided in the classroom, indirect support in the classroom to support that. Is that?
Yeah, that's a really good point. So if you have a reading and written expression is a need, and you decide to write, there's a goal in the IEP for reading, but not written expression, but written expression is addressed in the services through, say, indirect or consultative service. Yeah, that would be okay. That will generally be okay, but if it's a serious reading deficit, the child, or written expression, then it really should have a goal. But at the very minimum,
Because if the parents come back at us, then we would be progress monitoring it.
Yep.
Okay.
That's it exactly. Because if the parents said, I don't think my child is receiving a FAPE because there's no goals in written expression, and here we have an assessment that shows written expression is a pretty significant problem, that could be an issue that the school district needs to address. They probably, I generally tell school districts, if it's an academic area, if it's a functional area, you should be writing a goal. And of course, you should be doing a service too.
Okay, thank you so much.
Okay, yep. Okay, now, and then monitoring student progress. These are just a couple of quotes from Andrew F., which I think were really, this is a significant thing. A reviewing court may fairly expect school authorities to provide a cogent and responsive explanation for their decisions that show an IEP is reasonably calculated to enable a child to make progress appropriate in light of his circumstances. Now, why I think that's so significant is because in due process hearings, the burden of proof is on the party bringing the complaint. So parents, 99% of the time, are the ones that go to due process hearing. So the burden is on them to prove that a school district did not provide FAPE. But here the Supreme Court is saying, but it's still okay for hearing officers to expect school officials, IEP team members, to say why their IEP was reasonably calculated to provide to allow or enable the child to make progress. So that's a very important part. Now, I see we're running out of time here, but I want to go through a couple things. I'm going to skip up a little bit because we've talked about all these things already, but what I want to really concentrate on is I want you to understand the importance of the present level statement. And the critical point is when we write those need statements, those present level statements, they are the cornerstone of the IEP. They drive everything else. It's a statement that links everything together, and if we don't have appropriate baseline information, because essentially what a present level statement says is, here's where little Johnny is now, and our annual goal says, here's where he's going to be at the end of the year. We have to make certain that that is a baseline statement, because if it's really not, how do we monitor progress? If we don't have information in the IEP about where he actually, little Johnny, began in his reading, how we possibly measure progress? So that's very important. And what I've done is included a couple of test questions that you can look at, and these are questions that are used in a system used in Illinois to help teachers identify appropriate present level statements. And this is another one. These are like the critical elements of present level statements. Identify the student's need. What's the effect on general education? It must serve as a baseline, and it needs to be connected to a goal, a service, or both. But it always has to be connected to a service. Now, we've talked about this, so I'm going to go up a little bit more quickly. But the Council of State School Officers, of which your special ed director is a member a number of years ago, developed a summary statement for each area within the present level statement. And what they said is every statement should address these 4 areas at a minimum. It's based on the student has difficulty with, which hinders the student's ability to, and makes blank an instructional priority. That's just the Council of State School Officers. It's kind of a good summary to go by in writing your present level statement. Now, the second question has to do with what are the measurable goals. And what I've done is included a lot of just examples here, but this is the way it's defined in the federal law. And essentially what a goal does is it connects to the need. It says, this is the baseline where a child is. This is where we expect them to be in 1 year's time. This is how we're going to know if they get there. Measurable, you've all heard the term SMART goals, that we should write SMART goals, and it's actually, that's a term from business. Business schools have taught this for a long time about writing SMART goals. They should be specific, that is directed to a child's individual needs. They should be measurable. We should write them in ways that are measurable. They should be ambitious, but realistic, and they're time limited because goals are only for 1 year's time. Well, back in when I was an undergraduate in education, I was in history, and I had a professor who made everybody purchase this little book, which if you look at the top, it says $2. I don't think any books cost $2 anymore, but it's called Preparing Instructional Objectives. It was a method for writing lesson plans, which this Robert Mager developed in the 50s, actually, in the 40s, when he worked in the Air Force, because he was an efficiency expert. And he said essentially there are three components to all goals that must be present. That is, you have to have a target behavior. That is what you want to change, and it's got to be visible. It's got to be words read aloud, independent assignments completed, number of interactions. It's got to be something you can see and verify. The second thing he said a goal has to have is a stimulus material or conditions. Barbara Bateman used the term given. And what that means is, how are you going to measure the goal? Are you going to count the number of interactions he makes? Are you going to have him do a random sheet of math facts and count the words correct? Are you going to have them read words and count the words per minute? So you need to have all three elements in a goal for it to be measurable. Now, and this is kind of a graphic of these measures. And I also threw in timeline, because in Indiana, I believe Article 7, and correct me if I'm wrong, Matt, does say you have to have a timeline included in there. In South Carolina, we have to have that, so I just put it in. What I've done is given you a number of examples, and in this way, the red is the target behavior, and it's got to be visible. The green is how you're going to measure, and the purple is the criterion for acceptable performance. I have a number of examples here. In letter names, in math, writing, reading, comprehension, functional, and behavior. And I'm not saying that is the only way to write goals. I'm saying it is a good way to write goals, because if you have all three elements present, you will have a measurable annual goal. You almost can't help it. So that's one of the things we need to do in our IEPs when we look at our goals, is to make certain all these three elements are present. Now, I've also included some graphs for you and some measurable goals that you can take a look at. This is from a friend of mine named Jim Schreiner from Illinois that has developed a number of questionnaires. So what you can see is you can go through these on your own. They have a goal up there. It has goal checklists, yes or no, and you can just check them off. And determine it's yes or no. If you're answering all yeses, you have a measurable annual goal. If those three components are there, you have a measurable annual goal. So I'm not going to go through these different examples, but I have a lot of them here for you to look at. I have 3 or 4 different goals, and you can see how these were not my answers. These are the answers Jim gave to the student. And the third thing, the last thing we have to do, is monitor student progress. Make certain that you do that. Have a user-friendly way to monitor student progress that is easy for students to do. And the last thing I'm going to tell you is Kathleen Mayfitt, and we talked about this in our meeting yesterday, who's an attorney like Julie Weatherly, who only represents school districts, not parents. And she used to work, she actually just retired, with a firm called Reed & Smith in Virginia, where she represented special ed cases. And of course, 90% of all special ed cases and hearings are FAPE cases. And she said to this, I heard her say this in a conference 2 years before Andrew, and I'd say it's even more important now. She said, when I have a school district with a FAPE case, the first thing I do is go to the teacher and say, give me information on your student's progress. If I don't get any data, I consider advising the school district to settle. And as a hearing officer with these 3 FAPE cases I had last year, I looked, is the data there? Did they collect the data, which is the progress toward the measurable annual goal that they said they'd collect? And if they don't, and if they don't react to it, That's a very significant problem. And that is kind of a chart on the different aspects of progress monitoring. Make sure they're graphed. Now in Indiana, you have a descriptive element to goals, but you also have to put numbers in it. So you have to be able to graph data. You know where your baseline is, where your measurable goal is. Make certain you can graph data and report to a student's parents. Make certain you're frequently assessing a child. I'd say once every other week. In a very frequent and systematic way. Make sure your parents know. Report that to parents. There's just a case out of the Ninth Circuit where parents never received any progress reports. The court said that was a denial of faith because they didn't implement, because your IEP says you did. The IEP said they would report every 4 weeks, and they didn't. User-friendly and efficient, and make certain you use it for instructional decision-making. Shouldn't be just you collect data and then put it away. It's you collect data and decide, is a child making progress toward their goal? Okay, let's see, we went a little longer, I think. Not much though. So, well, thank you for coming. You guys are really intrepid people. And so you did great for you being here. And if you see Jolly and Matt's right back there, you can see him. Thank him for another great conference. And look for the Special Ed Law Conference that they put on every summer. That is amazing. And so it's a really good thing. So.